I'm 4 minutes late. I was getting coffee. 4 minutes. Good morning, everybody. My name's Debbie. Welcome to my channel. I was 4 minutes late. I'm sorry. I needed coffee. Okay, we are back with the Betty Broderick trial. We're on part 21. And Judy has trivia for us. Betty told her husband to get rid of Linda by the beginning of October or get out. Broderick chose Kolkena. And then she did the same thing with her kids. Quit calling the man's bluff, woman. Did she learn nothing? Dan and Linda Broderick's funeral, 5 days after their deaths at St. Joseph's Cathedral, saw over 600 attendees. Dang. Hey, Nichelle. Wow. That's sad. I mean, it's still sad. It's sad when anybody dies, but when I am feeling much better, Nichelle, thank you for asking. But when somebody has that kind of funeral, like they were well respected in the community and everything, that's so sad to me. My mom had a big, not that big, but a big funeral like that. And my mom did not feel that special. And I just hope somehow that she was able to know how special she was to so many people, because her funeral was the biggest funeral I've ever seen in person. Was my mom's. So okay, so we were on this judge person. I don't even remember his name. What? It's been so long since we've done this trial. He was the judge that oversaw some of their divorce stuff. Supposedly the judge that Betty said to Dan, to what do we owe this honor, and was like fawning all over him, which the judge said didn't happen. And I had said early on, how would that have even happened? Because they have the court case in front of them. He would have known that he was a party in the divorce case and not there as a lawyer, so it wouldn't have made sense for him to say that. And he also said that before he does a court case, the parties are already in the court, and he's not in the courtroom. He comes out from his chambers. So it doesn't make sense that he would say that. And he says he does not remember saying it. And it's not likely that he said it, so. Percival. And I think, actually, I can't remember if this is direct or cross. Because like I said, it's been, what, 5 days, 6 days?
The last thing you mentioned that there's forms that contemps are filed on, and it's not always that attorneys file back orders, and those would normally be kept back orders in the file itself, would they not?
Yes,
they'd already
they
be
would.
there.
Sure.
Okay.
And when I say that the attorney filed back orders, those were Xerox copies. The originals would have been in the file where it was located.
When he files an order, normally gets one stamp for himself that he keeps in his file.
Yes.
So even if an attorney files back orders, in the normal business, they're in court.
Oh, yes.
So normally there's not a need for the back orders because they're in the court file.
It depends on what they put in their pleadings. If they haven't included in their pleadings the language from the back orders or a copy of them, then the judge would go back up that there was a clear understanding of what it ordered.
I have a further question.
I never read it.
Filing the back orders in the pleadings is helping, for convenience purposes, of letting the judge know what some of the history is in the case. Is that fair to say?
That's correct.
Okay. And I take it, you indicated that you did know that Dan Broderick was an attorney.
Oh, of course.
Okay. And I take it that it's not unusual for you to greet all attorneys in a respectful manner.
I hope so. I want to.
And isn't it also true that, again, when you make your decision on a contempt, it doesn't have to do with the history or what went on or may not have gone on in the file. It has to do with the evidence that's presented to you dealing with those specific allegations in court.
That's partially correct, but it's not entirely correct.
Okay. Obviously, if you've been dealing with the case for some period of time, you know some history of the case. Is that what you're saying? Okay. And do you recall at all when you looked at the file, do you recall seeing any handwriting by somebody, personal handwriting over the documents?
When I saw the file in Vista, there was handwriting on a number of documents in the file.
Okay. And did you know at the time whose handwriting it was, or?
No, and I don't know now whose handwriting it was.
Okay. But this was handwriting written over the typed documents, for example?
I think it was written over and in the margins both.
Do you recall during any of the hearings, and again, you may not recall because you haven't had the opportunity to read everything, but do you recall that there was at any point where Elisabeth Broderick objected to you handling the case?
I don't recall. The reason I'm taking so long is I'm trying to think back. She was represented by counsel at some of the hearings, and she represented herself at other hearings. And there was some dialogue, at least at one of the hearings, about representing herself in what is a quasi-criminal proceeding. And I tried to explain her rights to her, and I believe she understood. And it may have been at that time that some issue was raised, but I don't have a clear memory. I really do not remember.
Okay. Obviously, if there had been, when she was represented by counsel, if there had been a challenge filed against you, you would have been aware of that.
Oh, yes.
Nothing further.
Any further, Mr. Irwin? Yes. When you say Mr. Broderick, you knew he was an attorney, you knew he was president of the bar, didn't you?
Yes, of course.
And you knew that also that he was on the committee that rates judges for elevations to other courts?
No.
You didn't know that?
I didn't know that, and I'm not sure that that's so.
Did you know that the president of the bar is also normally on the judges committee as to how procedures will be handled in court?
Oh, yes.
Yeah.
Are you talking about the fast track committee?
Yes. For
He
one.
was the chair of the fast track committee. Of course, I knew that. I was a member of that committee.
And you had worked with him?
Along with many other people, yes.
Yes. And you had also, he was a member of Inns of Court, in fact,
I believe he was.
and that's working with the judges, is that correct?
It's working with some judges, yes.
And just your memory is that you saw the writing in Vista, you don't remember that when you first got the file?
My memory is I saw it when I had the file in Vista, and I don't remember it when I first saw the file. I believe that it was placed in the file somewhere between the juvenile court and Vista.
That's no further question. Ms. Wells?
Well, I need a moment, Your Honor, based on those last questions.
All right.
Judge Joseph, did you make any rulings with respect to the contempt in this case based on your knowledge and/or relationship with Dan Broderick? Is that what affected your decision on whether or not to hold Elisabeth Broderick in contempt?
Your Honor, objection is beyond the scope.
Well, overruled, you can ask that.
Absolutely not.
Did you not, in fact, tell Elisabeth Broderick during the course of one of the proceedings?
Your Honor, I object. This is beyond the scope.
This is proper. You went into his acquaintanceship, familiarity with Mr. Broderick, so
In
it's...
1987, when he first came in the courtroom.
Well, and this is proper recross as to whether or not his familiarity affected his rulings. I'll allow it. Go ahead.
Did I ask that question, Your Honor?
The inference can be made, Mr. Early. I'm going to allow the question. Go ahead.
Isn't it true that you, in fact, specifically told Mrs. Broderick that you did not consider Mr. Broderick to be a friend on a social basis, that you did not have a special relationship with him, that you had seen him as well as other attorneys in San Diego County, and that one of the reasons that the case had come to you to begin with was that there had been challenges of other judges and that you felt that you could handle this case in an appropriate way?
Your Honor, objection. Count.
Sustained.
Did you not tell Mrs. Broderick that you don't think Mr. Broderick could support to be on a social basis? And did you not tell her, I know no special relationship between us. I have seen him as I have hundreds of other attorneys in San Diego.
I told her that.
Did you not tell her that one of the reasons that this case came to this court to begin with is I believe...
Your Honor, I'm going to object as to the leading nature of the
This is
question.
She's on cross. She's going to leave.
Well, Your Honor, there are case law that it appears that she's calling him as her own witness at this time.
No, this is, she's rebutting the inferences you brought up on your last series of questions. Go ahead.
One of the reasons that this case came to this court to begin with is I believe there had been challenges of other judges, and I felt that I could handle this case in a fair and appropriate way. Did you not tell her that?
Ms. Wells, I assume that you're reading from a transcript, and based
Yes.
thereon, I'm answering the questions yes.
Okay.
What I can tell you is I don't know right now that those are my exact words. I certainly said something that was very close to that if I didn't say those exact words.
Okay, and I think that's fair. If I could show you a transcript dated May 4th, 1988, the bottom of page 60 through the top of page 61, if you could just read that to yourself to see if that refreshes your recollection about what you told Mrs. Broderick.
Yes, I believe that's accurate.
And did you believe, Judge Joseph, that you could handle those hearings in a fair way, fair and
Absolutely.
appropriate way?
Yes.
Did you feel that you were influenced in any way, shape, or form by Dan Broderick in making your decision?
I'll object, Your Honor.
Sustained.
Well, why did you hold Elisabeth Broderick in contempt?
Your Honor, I'm going to object, Your Honor.
Sustained.
Have you had other divorce cases before you that involved attorneys, Judge Joseph?
Yes.
It's not uncommon for attorneys and even attorneys who are considered prominent attorneys in this community to go through divorces. Is that fair to say?
That's fair to say. A number of judges have been through divorces in this county.
And prominent businessmen have been through divorces in this county.
Yes.
I guess I have no further questions at this point.
Thank you. Mr. Early.
Sir, at the hearings that you just alluded to, where you made the statements to Mr. Broderick, you did make some statements that you were,
I believe counsel misspoke. The statements were to Mrs. Broderick.
I'm sorry, the statements that you made to Mr. Broderick, you did indicate when you made those statements that you were going to do something as a request of Mr. Broderick, did you not? Different than you had intended to?
Yes. Are you speaking of one specific hearing?
Well, that hearing in May.
I believe that's the hearing. Yes, I think I did.
And did you, at the time that you made the statement to Mrs. Broderick at that hearing, you'd received some communication from her, hadn't you?
I had before that hearing, yes.
Okay, and in some communications, she had talked about reporting you, making a report about what she thought was a gang rape and unethical conduct, hadn't she?
I don't think so. I have a copy of the letter that I'm thinking of with material from the Broderick case. I'd have to reread it. I think I would remember the phrase gang rape. And
She never made any complaints about, you don't remember her ever making complaints about you sitting on the case before that hearing?
oh, I think she had expressed disagreement with my being on the case, yes. But I don't recall, Mr. Early, I have the letter that I'm thinking of. I don't know if it's the same letter you're thinking of. I could read it again. I'm sure that if she had indicated that she felt that she had been the victim of a gang rape, that I'd remember it, and I don't remember that.
Do you only remember receiving one letter from her? Is that
Yes,
correct?
there was one letter that I remember very specifically receiving from her.
Okay, but are you saying that's the only letter, or there were a number, or?
Right now, I don't recall other letters. Maybe there was more than one, but there's one letter that I do recall.
I have no further questions.
Anything further, Ms. Wells?
Not at this point, Your Honor.
Thank you.
Thank you.
The witness is specific to recall.
All right, so just recall. Thank you.
Call Judge Calvin.
Raise your hand, sir. You do solemnly swear the testimony you're about to give and the matter not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could you please introduce your witness stand?
Morning.
Could you please state your full name for the record and spell your last name?
William Joseph Howat, Jr., H-O-W-A-T-T,
Thank you.
Sir, what is your occupation?
Judge of the Superior Court, County of San Diego.
In 1988, were you assigned a trial of in re marriage of Daniel T. Broderick and Elisabeth Broderick?
No, it was in 1987.
1987 you were assigned?
In October of 1987, actually September of 87, I was appointed to the Superior Court from the Municipal Court in El Cajon. When I came to the court, I was given the file, the Broderick file, because Judge Joseph had just been transferred to Vista. So I was assigned the case in 1987.
And were you assigned it for all purposes?
That was my understanding, yes, and I dealt with it as such.
Okay. And at some point in time, were you aware that court file or portions of the file were missing?
Yes, from the very outset.
Okay. Was the file reconstructed at any point?
Portions of the file were given to me at various parts during the time that I handled the case.
Did the the file that was missing, or the portions, were you able to ever locate that yourself?
Personally, no, but I was told, I don't remember whether it was a,
I'd object to any percent.
All right, this is stand.
Did you become aware sometime after November 5th, 1989 that the file had been found?
After November 5th, 1989?
After-
Yes, but not during the course of the trial.
Was parts of the file reconstructed?
Portions of what were purported to be the file were given to me at various points during the trial. For example, do you want me to explain?
Yes.
For example, when we were dealing with the issue of closing the courtroom to the press, letters were given to me that had been letters written by psychologists who had interviewed the children, which were part of the reason that I closed the hearing.
Those were part of the prior court file?
I assumed that they were part of the court file from the tenor of the letters, but they were given to me to read and consider, and I believe that they were given to me by Mr. Barry in the court proceedings so that I might consider them, along with my interview of the children.
Okay. At some point in time, did you receive other pleadings from Mr. Barry to assist in hearing the trial?
I can't recall any right now.
Do you remember receiving a letter from Mr. Barry informing you that he was giving you some pleadings for the purpose of the divorce and that he would, if he located the lost file, would return it to you?
I remember you showing me such a letter, but I don't remember receiving such a letter.
Okay. So the first time that you remember seeing a letter from Mr. Barry as to finding the file was
The same.
you remember seeing the letter, is that correct?
You showed me a copy of the letter, yes.
And you did not, that's a letter that you never received?
I don't know whether I received it or not. I don't have a recollection of receiving it. Usually my practice is when I receive letters relating to a file is to mark them in the corner with two letters, RR, which stand for received and read, and my initials.
And at some point in time, was other pieces of the file reconstructed for you at all?
I'm not sure. I would say probably, because during the course of the trial, various things were presented to me. And I seem to have a recollection that Mr. Barry presented certain parts of the pleadings that related to the trial to me during the course of the trial.
I have one moment, Your Honor.
Certainly. Cross-examine.
Good morning, Judge Howard. You indicated that there were some letters that you recall receiving that dealt with the issue of whether or not the hearing should be open or closed. I'm just going to show you what's been previously marked as People's 103, 101, which is a series of 3 letters. If you could take a look at those and let us know if those are the letters that you're referring to.
They are from the people that I remember receiving letters from. Without reading them entirely, I couldn't tell you for sure. And it's been a couple of years anyway. But these are the people that I received or looked at letters from, which were Dr. Sparta, Dr. Roth, and this other person who I was not familiar with and still am not familiar with, Audrey Taryn Phillips.
But do those letters deal with the subject area of whether or not having an open trial and having the information that was going to be going on in that trial would be harmful to the children?
Your Honor,
if it became a matter of public knowledge?
Your Honor, I object to this area.
Well, the best evidence letters speak for themselves.
It is your best recollection that those are the letters that you received, is that correct?
I received letters directed to the reader, the newspaper, the reader, from these people and considered them in making my determination to close the hearing.
Are you saying that you can't identify those? If you could take the time simply to...
Sure. They appear to be the letters that I considered, yes.
And there was an issue that was brought up during the course of the trial that you handled with respect to whether or not the hearing should be open. Is that correct?
No objection beyond the scope of direct.
Now sustained.
She gave some paranoid reason as to why it was closed, why the trial was closed, the divorce proceedings
You
were
handled
closed.
the actual trial litigation which occurred during December of...
And I don't remember what it was. But when she was on the stand, she went on and on and on about how the divorce proceedings were closed so nobody could see the truth or something. Like, she went on and on about how unfair it was.
1988 through January of 1989, is that correct?
That's correct.
And again, was that a hearing in which evidence was presented to you? You made your decision based on evidence and testimony of witnesses, is that correct?
That's correct.
It's a trial, the same thing that we're doing here, except for we don't have a jury, we have a judge who makes the decisions.
That's true.
So you're making a
Your
decision.
Honor, objection is beyond the scope of direct.
Well, doesn't really affect what she's getting to is whether or not the lost file had any effect on its decision. So go ahead.
Were you making your decisions, therefore, based on the evidence that was presented to you during the course of the trial, as opposed to what might or might not have been in the file?
Yes.
And when you handled this trial in December of 1988, were you a close personal friend of Dan Broderick?
Your Honor, objection is beyond the scope of direct.
Sustained.
Okay, I have no further questions at this point.
Redirect.
Do you consider the pleadings documentary trial?
Normally not in a domestic case because the issues are pretty straightforward. You know that there's going to be a division of the property. You know that there's going to be usually a question of the custody of the children. And so for the most part, I wasn't concerned with the pleadings because the nature of the property and extent of it would be presented during the course of the testimony and was in fact done so.
So there's no need to supply any pleadings whatsoever?
It's a help to the court, sure.
Okay, and I take it that when you read, whatever pleadings you read are not erased from your memory. They're still there.
Well, I don't know. It's been a long time since then, and I've been handling other cases.
No, but what I'm saying is that obviously if you read something,
Objection, leading room.
Well, that's proper area. Go ahead.
when you read something, that's something that's in your memory at the time that you're doing it.
If you mean, would I consider the pleadings in relationship to the course of the proceedings that I was hearing? Yes, certainly.
Okay, that's all I was asking. Thank you.
Recross?
Did you receive any letters from the defendant in the course of this trial? Do you recall?
I don't recall receiving any from Mrs. Broderick,
Do you
no.
recall receiving any letters from her after?
No, I don't. She did present during the course of the trial a rather lengthy statement that, if I recall correctly, we made part of the proceedings, part of the record of the proceedings, because she felt awkward testifying.
Okay, thank you.
Anything further, Mr. Early?
No.
Witness be excused?
Yes.
Subject to recall.
Thank you very much.
Officer Sweeney.
You do solemnly swear the testimony about to give in the matter not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Officer, could you please have a seat and witness stand?
Morning, sir. How are you?
Thanks.
And officer, could you please state your full name for the record and spell your last name?
William Scanlon Sweeney, S-W-E-E-N-E-Y,
Thank you, sir.
Sir, what is your name?
police officer with San Diego City,
And how long have you been so employed?
about 9.5 years.
In February of 1986, were you, I take it you were so employed as a police officer?
Yes, sir.
And did you have a occasion to respond to a home on Cypress that belonged to a Mr. Daniel Broderick?
Yes.
Okay, and was that in relationship to an incident of where somebody had hit his front door with their vehicle?
Yes, sir.
Do you recognize the person here at the end of council table?
Yes, sir.
And did you see her there that day?
Yes, sir.
Okay. When you, did you have an opportunity to talk to some people who were present at the time that Betty Broderick was there?
Yes.
Did a daughter of hers leave Broderick?
Yes, I did.
Okay, and at the time that you talked to her, did she make any statements in regards to a knife?
Yes.
Overruled. You can answer that. Yeah, well, the answer stands.
Okay, and what did she say about the knife?
She said that her mother had made the statement that she wanted to go out to the car and, I believe, kill herself with a knife.
Did you find a knife in the car?
Yes.
Did you did you talk to Mrs. Broderick?
Yes.
Okay, and how would you describe her at that time?
She was somewhat angry and seemed depressed.
Now, you wrote a report in this, is that correct?
Excuse me?
You wrote a report in this matter, didn't you?
Yes, sir.
Okay. Was there, did she appear to be upset or angry to you?
Objection, asked to answer.
Oh, sustained.
Is angry the only description that you feel is an accurate one?
Objection, asked to
Well, you can answer that, go ahead. You said angry and depressed, go ahead. Any other emotions you noted, officer, do you recall?
Not that I recall.
Okay. Did you write a description in your police report in regards to how she appeared to you to be at the time?
Yes.
Okay. I'd like to show them the report. Do you have that? Thank you.
If you could read page 4, just read it to yourself, officer.
Second paragraph.
Got
Have you read that?
it. Yes, sir.
Okay. Does that refresh your recollection as how you remember her?
Yes, sir.
And how was that?
Very upset and depressed.
Now, at the time that you, were you aware of another home on Coral Reef?
Later on, Mr. Broderick mentioned that.
Okay. Now, did Mr. Broderick tell you whether he had been to Coral Reef?
Yes, he did.
And had he?
He told me he had after I got back from.
Did you go to Coral Reef at all?
No, I didn't.
Did you ever receive a gas can?
No.
Were you ever told about a gas receipt?
Yes.
Did you ever receive a gas receipt?
No.
Did you take Elisabeth Broderick somewhere?
Yes.
And did you return to the residence?
Yes.
And when you turned to the residence, who was present?
Best of my recollection, Daniel Broderick. I think some of the family members are there, and I believe his then fiance was there.
Did you know that that person was the fiance?
Same.
I have no further questions.
Cross down.
When you first arrived at the residence, officer, where was Elisabeth Broderick at the time? Do you recall?
She was standing off to the side of the car that was in front of the front door of the house.
And was it obvious to you at the time that you got there that there had been some significant vandalism to the house?
Yes.
In fact, you ended up arresting her for felony vandalism, is that correct?
Well, I took her to CMH. I did a notify warrant later for the vandalism.
Okay. And there was information you received from Lee, her daughter, about her mother having a knife. Is that correct? That's where that information came from?
Yes, ma'am.
And where did you find the knife?
It was on the. Can I refer to my report?
Sure.
I found the knife in the driver's floorboard of the car.
Do you know how long she had been standing there near the car before you arrived?
No, I don't.
Obviously, she had made no attempt, as far as you were aware of, to do anything to herself with that knife before you arrived. Is that fair to say?
Yes.
And you indicated that she appeared angry to you. Isn't it true that when you took her down to CMH during the entire drive, she was very angry during that drive?
She was upset, yes.
And she was complaining. Have you described her complaining like a whining kid?
That would be an accurate description.
And while she was complaining to you during the car ride down to CMH, she wasn't crying, she wasn't sobbing, she was simply making...
Your Honor, may we approach the bench?
Well, if you got an objection, just make it.
Well, my objection, Your Honor, is I was not supplied with any discovery or any notes.
Assume is this in his report?
No, that is not in this report.
Why not?
I asked you, officer, about taking the defendant to CMH. Can you tell us what CMH stands for?
County Mental Health.
And that was in lieu of taking her to jail, which was an option, is that correct?
Well, after certain things are brought to your attention, that was no longer an option.
And basically, is it fair to say, and you can correct me if I'm wrong, that in any sort of situation as a police officer, when you contact someone, if there are threats of suicide, then you are instructed that to be on the safe side, you should take them to CMH as opposed to jail?
That would be one factor, yes.
Also, when there are indications that the person may be a danger to others, and you are not necessarily going to put them in custody, is that another thing that you take into consideration as far as whether or not you take them to CMH?
Yes.
And you did have a conversation with Elisabeth Broderick where you asked her about the fact of whether she knew that there was a restraining order against her with respect to that property, correct?
Yes.
And she indicated to you, when you asked her, did you drive your car into the house? Her answer was, sure did, correct?
Yes.
And when you asked her why did she do it, her answer was because he refused to talk to me. Is that correct?
Yes.
And is it also true that when you were first there at the house, not after you returned, it was when you were first there that Mr. Broderick told you that she had threatened to go and burn the house at Coral Reef? At that point, he was not aware whether she had or not, that she had indicated a threat to do that, correct?
I refer to this.
Sure. I can direct your attention to page 4.
Correct.
Okay. I have no further questions.
Redirect?
Yes, the questions you referred to, what you were told is that she had threatened to commit suicide in the past and had threatened to burn down Coral Reef in the past.
My report says that he told me that she had threatened suicide in the past and said she was going to burn the house down on Coral Reef.
In the past or that day?
As my report reads, I really can't recall what was meant.
Okay. I have no further questions.
Recross.
Your report reads that she had threatened suicide in the past and that she was going to burn down the house on 5555 Coral Reef, correct?
Yes.
And he also told you that she had threatened to harm him several times.
Yes.
Mr. Early?
And also, he said he wanted her committed. Is that right?
Yes.
I'm sorry, was there an answer?
Yes.
Okay.
That's it, Mr. Early?
Yes.
Ms. Welch?
He said that he felt she needed help, didn't he?
He also said that. He said that he felt she should be committed.
Definitely correct.
Mr. Early? Witness to be excused? Thank you very much, officer.
This video is a bad format where it was just playing fine a second ago. I think that was the end of that video anyway. What are you doing, computer? I think, are we done with that video? What are you doing, computer? Okay, I think we're done with that video. I think that was the end of that video. I don't know what it's doing. It's stupid court TV website. I don't know. Okay, guys, so that's all we're going to do of Betty today. We will pick up where we left off tomorrow morning. Now we're going to go to Florida for day 1 of the penalty phase of the Soto Escalera trial. So, this is supposed to redirect you. If it doesn't, I'm sorry. I did everything right. I can't control YouTube. YouTube is crazy. So it should redirect you. So we're going to go to Florida for that. What I'm going to do about the baby in the river trial is when this court goes to lunch, because they've been taking really long lunch breaks, I'm going to do the baby in the river trial so we don't fall too far behind. And then when the lunch break is over, then we'll go back to this. And then if they end early, then we can go back to the other trial so we don't fall too far behind until the penalty phase is done, and then we can catch up with the other trial. This is crazy, I know. I don't know why I did it this way. I think I wasn't thinking well whenever I was hurting so bad and thought we could do this do this extra trial. I don't know what I was thinking, but we're gonna make it work. We're gonna make it work. So, okay, guys. So I will see you in the other stream in about 10 minutes. Bye.